Good evening. This is Laws 19038, Planning and Environment Law. It's John Milburn, the course coordinator. We're now into week 10, and we're dealing with environmental administration and management, the prescribed reading, Bates chapters 6 and 14. I'm going to talk about some certain specific aspects of environmental administration and management, and in that regard there are 4 topics. The first is I want to discuss the difference between merits reviews and judicial review. The second is the concept of standing in environmental litigation, and in that regard I'm cheating a little bit because this is to do with chapter 17 of Bates, which is coming up in your reading. The third is in relation to criminal prosecution or criminal enforcement as a means of managing environmental issues. And the fourth, which is probably even more effective way of managing environmental issues, is through the costs regime in court proceedings. So firstly, merits reviews and judicial review. You would have seen these concepts coming up quite regularly. In essence, they're really quite simple. A judicial review is a review by, as the name suggests, judicial, a judge. So it's a judge reviewing something. And what the judge is reviewing in judicial review is essentially the legitimacy of the decision. Couple of questions. Was the person who made the decision authorised to make that decision? And secondly, if the person was authorised to make the decision, was the decision made according to law? Was it made in circumstances where it was lawfully arrived at? Were the correct procedures followed? Was it a decision that is lawful, essentially? Now, in that sense, without being too flippant about it, the judge in a judicial review really isn't concerned about what decision was made. That's not their role. They're not concerned about the merits of the decision. Was it a good decision or a bad decision? The real question is, was it a lawful decision made by a person with lawful authority to make the decision? That's what judicial review. So it's made by a judge. In Queensland and at a Commonwealth level, there is specific judicial review legislation. So it's worth having a look at in the context of your studies. The second is a merits review. A merits review is administrative in law. It's an administrative decision. Now, being a member of the Queensland Civil and Administrative Tribunal, I can tell you that I do quite a lot of merits reviews in the context of that tribunal. In the context of environmental law and planning and environment law, the decisions which are made by the Planning and Environment Court are also essentially merits reviews decisions. So what is a merits review? Well, a merits review is where the court or the tribunal is asked to reconsider a decision that was made, not by picking the original decision to pieces, not by asking questions about whether the decision was right or wrong in the way that the decision maker went about the process of deciding. None of that. It's essentially a brand new decision. The decision maker at the tribunal or court level, as it were, steps into the shoes of the original decision maker and listens to everything afresh and then makes a decision. We call it the decision maker making a correct and preferable decision in relation to the matters before it. So that's what a merits review is. It's administrative law, and it's essentially the decision maker taking the decision away from the original decision maker and making the correct and preferable decision, as we call it. Okay, so that's merits review versus judicial review. The second thing I want to talk about is the concept of standing in environmental litigation. Well, what's that mean, standing? Or even getting worse, the Latin is locus standi. Let me put it to you this way. If you want to go to a court or a tribunal, there are 2 things that you need to show. The first is that you've got a good cause of action. That is, this is a proper case that can be argued at law. It's not some nonsense that really has no basis at law. It's a good, solid action. But before that, the preliminary point is, are you a person who is entitled to come to court and argue this cause of action? I mean, let's say I'm having a chat with a person who lives 3 doors down from me, and that person 3 doors down from me is complaining that he built a fence and his rotten neighbour wouldn't contribute half. Now, if that person went to court and said, under the Act, my neighbour is required to pay half and I'd like that order to be made, the court will say, yes, you're correct, and because you built the fence and you're the one that's out of pocket, I'll listen to you on this argument. Now, what if I went to court and said, look, Your Honour, I want an order because the person who's 3 doors down for me is not willing to pay the person next to him? That might be a good cause of action, but the court's going to say, Mr. Milburn, you have no right to be here in relation to that dispute. It's not your dispute. You know, you have to have standing to come to court on that dispute. You have to have locus standi. So the litigant must be relevant to the proceedings. Now, what does that mean in the context of environmental law and planning and environment law? Essentially, only those people that have a legitimate interest in the proceedings have the right to get their foot in the door to ask for an order to be made. If you don't have a legitimate interest under common law or statute law, then the court won't hear you. And when we talk about the court not hearing, that's not to be meant literally. It means, of course, that the court won't consider the matter. So you need to have what we call a sufficient right to have the dispute heard by a court or tribunal. And generally speaking, standing is conferred upon a person or an organisation that is aggrieved. My neighbour 3 doors down, he's aggrieved because he's out of pocket. I'm not aggrieved because it's got nothing to do with me in terms of the neighbourhood dispute down the road. So what does it mean in the context of environmental law to say that you need to have this proper standing? What does it mean in real terms? Well, it means that you need to establish a right at common law, or it needs to be established by virtue of statute. In general terms, the ability to show standing at common law is harder to show than if you're relying on legislation. From a public policy perspective, Parliament has thought it appropriate to make legislation which extends the common law to the point where lots of people have the right to argue that they have standing when it comes to environmental litigation. Look, in New South Wales, they've gone the whole way. They've said, look, everybody has a right to come to court, to bring proceedings, to ask for an order in relation to an environmental issue, or to enforce or restrain a breach of environmental statutes. So they've gone the whole way. Essentially, the concept of standing is out the door. But that's not the case in other jurisdictions, including Queensland. So statutory entitlements need to be looked at in the context of the actual act that you're considering at the time, but in general terms, it's more extensive than it is at common law. At common law, you really did have to show that you were adversely affected by this environmental issue because it had an effect on your property or it had an effect on your economics. So conservation groups may have had difficulty in the past relying on common law issues. But at common law, it wasn't just economics or property. It was also some special interest based on social or cultural or political or environmental issues. So Indigenous litigants may argue, for example, an entitlement based on social or cultural in certain contexts. So you can always rely on the common law, but more likely you rely upon statutory authority to bring your matter before the court. There are some alternatives as well. If you're really stuck and you don't have standing, either at common law or by virtue of statute, it may be that you can lobby the Attorney General to join the proceedings, and the attorney would have the ability to join as of right. probably in what we call a relator action. Another way that you might be able to get your foot on the door economically perhaps is to somehow join a class or representative action. That can be a useful tool, and there are specialist firms that will engage in representative or class actions. So that might be a way to do it as well. All right, so in the context of the overall topic for this evening, which is environmental administration and management, firstly, we've talked about going to court. What type of order do you want if you're complaining about the way that the environment has been administered or managed? And secondly, what is your right to get there through standing? Now, when it comes to enforcement through management or administration, one of the most potent tools available to an administrator is the ability to bring criminal proceedings. It's reactive, meaning that it's after the event, but it's still very powerful. And certain statutes provide that it is not only a civil issue, but potentially a criminal issue where there has been some breach of environmental standards. So, for example, you might look at the Environment Protection Act of 1994 in that regard. To prove a criminal offence, there's a couple of basic things. The first is that the prosecutor needs to establish the elements of the offence. Now, there might be 1, 2, 3, might be 5 different elements that you need to establish before you can say that this is a successful criminal law prosecution. You might need to prove the jurisdictional aspect, the intention aspect, etc. So those things that are part of the legislation that are critical are what we call the elements. And also, the prosecutor needs to establish the guilt beyond reasonable doubt. So in a civil jurisdiction, generally speaking, we're talking about what we call the balance of probabilities. What's more likely? Is it this or is it that? But in a criminal jurisdiction, the prosecutor must establish the elements beyond reasonable doubt. There are some other things that apply in criminal proceedings that don't generally apply elsewhere. And one of them is the rule against self-incrimination. In other words, there is a privilege which attaches to everyone, and that privilege is that they are under no obligation to incriminate themselves in relation to potential criminal activity. Now, that applies during the course of investigation by environmental managers and administrators, but it also applies in a court context. So if one is under oath, then even in a court, if asked a direct question, that person is entitled to say, I'm not willing to answer that question on the basis that to do so would incriminate me in relation to a criminal matter. There is just one exception to that, and that is, it's not very common, but the Crime and Corruption Commission, for example, does maintain coercive hearings. So if you're summoned to one of those coercive hearings, subject to various orders that are made by the presiding commissioner, you will be compelled to answer questions even against your own self-interest in those circumstances. But that's a very specialised exception. So the general rule is you don't have to answer any questions which will incriminate you. And indeed, I can go further than that and say at the investigation level, if you're under consideration for criminal proceedings, you don't have to answer any questions to the prosecuting authority or the investigating authority other than perhaps your name, date of birth and address. So just bear that in mind, and that's a special issue in relation to criminal enforcement. There are different categories of offences, and in general terms, there's a category which is called indictable, which is essentially the more serious, as opposed to summary, which are the less serious. Now, it's not as clear as that, and the guidelines are a bit blurred at times, but just think in terms of indictable being more serious and summary being less serious. I mean, technically, when we talk about indictable, it means, or originally it meant that it's an offence which is capable of being the subject of proceedings through indictment. An indictment is just a piece of paper, essentially, which is presented by a prosecutor to one of the higher courts, a district court or a Supreme Court before a judge, as opposed to other proceedings which are commenced not by indictment, but other proceedings which are commenced in a magistrate's court through different other means. So that's indictable is more serious, summary is less serious. But some offences are what we call created through strict liability. That means the mere fact that it happens and you are the person that caused it to happen is enough for you to be convicted. So in environmental litigation, there are some instances where the liability is strict. Polluting huge vast quantities of the Great Barrier Reef with an oil slick is going to lead to a prosecution with strict liability. But for the most part, the liability needs to be established by certain elements being included, and one of those would normally be the intention to commit an offence. So, I mean, if, for example, I was charged with dangerous operation of motor vehicle in circumstances where I hit someone and caused them grievous bodily harm, I mean, it might be that I actually went out with the intention of causing someone grievous bodily harm, so willful intent. But that would be perhaps uncommon, and it's more likely that my actions were caused through recklessness or negligence. I mean, for example, if I was driving and the reason the person was knocked over was because I was, I had my head buried down reading a book or something and not concentrating on watching the road. I didn't mean to hurt anyone, but I was reckless to the point where my actions would be regarded as being of criminal liability. So that's what we mean by intent or recklessness. Now, just on that question of criminal liability, bear in mind that there are defences which might be available, and in an environmental law context, perhaps the most common would be an honest and reasonable mistake of fact. Not a mistake of law, but a mistake of fact. So that would be a usual defence, or perhaps a defence of due diligence, that you performed everything diligently, but it's just an unfortunate accident or consequence of the matter, short of strict liability, as I talked about before. Okay, so there's some of the issues. Just also in the context of criminal prosecutions being brought by an environmental manager or administrator, generally speaking, when it comes to imposing a penalty, the court will be more lenient if there is a plea of guilty, as opposed to being found guilty after a trial. So we can't say there's a discount necessarily, but we can't say there's a penalty for taking the matter to trial, but we can say there's a discount for an early plea of guilty. So keep that in mind. And when it comes to sentencing, there are a whole different range of things. When I talk about a sentence, I'm not just talking about a term of imprisonment, although that is one. A sentence might be a fine, or it might be community service. A whole range of things that it could be short of prison. And when we talk about prison, we're not just necessarily meaning a term of imprisonment. There's different types of prison. It might be prison to be served, subject to a suspended sentence, or it might be prison subject to release on parole at a certain period of time, etc. So there's those different aspects as well. And one very important thing, if you're advising someone who is subject to criminal law proceedings, you need to discuss the question of a conviction being recorded. And that might be the most critical thing as far as the defence is concerned. Whether a conviction is recorded, which might have ramifications in terms of employment, job prospects, travel, and a whole range of things. So that can be very important. Generally speaking, if it's a Commonwealth offence, a conviction will be recorded. It's very hard to escape a conviction being recorded if it's a Commonwealth prosecution. It's much easier in a state jurisdiction. Okay, so that's what I wanted to talk about in the context of criminal prosecutions, and I do so in the overall context of the way in which administrators and managers take action in relation to the environment. The final thing is the question of costs, legal costs. And you've seen this in the reading from various times. Now, legal costs is a really important and potentially very serious matter. What I mean by that is that it's all very well to say, I'm going to litigate a matter, I've got standing, I'm going to go to court and take on somebody. But if you lose, you run the risk of the court ordering that you pay the costs of the other side, which means you pay your own costs and you pay some part or all of the other side costs. And environmental litigation can be really expensive. You know, for a developer with a team of lawyers and experts for a 3-day trial, you know, the costs may be $50,000, $100,000, $200,000. You know, pretty substantial money. So if you're advising someone that wants to embark on challenging the way in which some sort of environmental decision has been made, just think about that question of costs. Now, if there is a costs order against you, it'll be one of two types. It'll either be what we call a party and party costs order, or solicitor and own client or indemnity costs. Party and party means that you pay the other side's costs, but not necessarily all of them as per the bill of the solicitor who acted for them, but rather you pay a certain fixed amount for certain aspects of the litigation which are set by statute. That's what we call party and party, and typically that would be much less than the actual bill which is given. In some circumstances, the court will order that you pay the actual bill, which is what we call the solicitor and own client costs, or perhaps indemnity costs. Okay, so I know I've departed considerably from the actual content of Bates' text, but I wanted to give you some specific areas which I think are important in the context of environmental administration and management. I do hope that you're enjoying your reading. Thank you very much for those of you who submitted your paper for assessment number 1. I was generally really pleased with the work that was done, and I'm looking forward to the work for assessment number 2. Keep up your communications through UCRU. I see that it's becoming a little bit more interactive, and that's great to see, and I really appreciate that. If you have any questions otherwise, please send me an email. We'll go from there. All right, all the best, and we'll see you next week. Bye.